This video will concern the law, firearms, the ATF, and many, many other things. And I will try to give you the practical advice at first, but warning. This is going to be talking about the actual subject of A, modifying equipment, which actually borders on breaking the rules about demonstrating or discussing it on YouTube. But it's part of how the law works, and that's why I'm discussing it. So if you're a YouTube reviewer, I'm discussing the subject matter itself. I'm not instructing people. So flagging the video would be disingenuous at best, and at worst, shutting me up so somebody can get into trouble. I'm trying to prevent people from breaking laws and getting into trouble, which is what you guys stated on your blog as to why you're telling people you can't show people modifying firearms as a demonstration on YouTube or discussing it. I'm discussing not doing it. Okay, now I'm going to get to the practical example. And this, again, is not instructing you how to do something. This is instructing you how to avoid breaking the law while trying to do something that is legal in the United States. Period. In order to get around the problem we're going to be discussing today, let's get the practical shit out of the way. You go to a large, hard-to-sue by the ATF hardware or auto parts or plumbing supply company, like a chain store like Lowe's or whatever. And make sure it's a place, or you use several places, that have everything you need to build a particular thing that you're trying to get to be checked out. Is this okay for me to do this legally? And am I allowed to do it only with restrictions, so I have to pay a $200 tax stamp or whatever to get approval, or a $5 one? Depending on what it is, you may only need to pay $5. You need to make a list of and take photos of every part and tool, all of them, that they're still on the shelves so that they show that you're not in possession of them. You write up a detailed description of the process and the tools and parts, inserting them, and mentioning the costs as a prelude to saying, you beginning every step with, I would have to go to the store and purchase these items. And then insert the photo, price tag, and the handwritten note you gave as to where you were going to get it from, including the address if you want. This provides photographic evidence of your intent to proceed with an act, but not having the ability readily at hand to do so. That's not a legal term. That just means you're not able to do this, and you don't possess the components for something that you're either A, asking the federal government, or the ATF in this case, is it legal for me to do this? Do I have to get a permit? And implied, I want you to tell me whether I'm allowed to do this legally, and I need you to tell me if it is restricted, how much the tax is, and here's the tax money because I've been told to include $200. And I filled out your form on eformsatf.gov. Only after obtaining approval and or tax stamp, or being told, no, you can't do that, don't do that, please, the ATF is legally compelled to tell you before you do something. They don't have the right to say ignorance of the law is no excuse, because that has been determined to be a lie. They have to tell you there's a law against that, because they have to presume you don't know, because you're overtly asking them. Let me repeat that. You're not just asking permission from an agency. You're telling them you don't know if it's illegal or not to do this. You haven't done it yet. You don't have any of the components or tools, emphasis added, or tools in your possession at all, and you're proving it by showing things on the shelf with a price tag underneath it. Get that focus just right. Now, what is this about? Number one, we're going to be taking these following statements as axiomatic. The ATF has demonstrated a predilection and previous occurrences of them deliberately telling people, we're going to let you do this. You don't have anything to worry about. And then weeks, months, or years later, changing their answer, and then using every single inquiry they had to go raid someone's house, shoot their dog, threaten to hurt them, and in a couple of cases, and I'm going to say this, overtly went out of their way to basically murder 5 people so far. It's only over a 10-year period of time, so I guess that's okay. The ATF is actually guilty of doing this, and they've been found guilty of doing this, which means they've lost the ability to claim ignorance of the law as an excuse. The ATF is literally under a ruling that says, if you say, I don't know what the laws are because they're convoluted and I need you to tell me, you get a technical letter or you get the legal letter. If you pay them the $200 for a tax stamp, they are required under federal law not to lie or set you up. And when you submit that form and all the data with it, you better be thorough, they're not allowed to use it in a court of law because you have a presumption of innocence and ignorance of the law. They can't complain about it as long as you haven't shown that you're committing a crime. They can just still come through and raid the place and take your shit, but they can't prosecute you because it's an unfair thing to do. The whole point of the technical letters, if you're not aware of it, is where you ask them, am I legally allowed to put a conversion device in a flare gun and fire a bullet? And then when, not if, the first time you do this, they deliberately come up with a scenario that has nothing to do with you. Like, well, Thanos is next door, so. Then the second time you say, on your previous letter, you overtly dodged the question. At this point, it will become a federal case. I mean, you literally put that on the paperwork. And depending on which nitwit is answering, they might actually dare you. What you do is you bring up, it's illegal, according to federal law, for them to go out of their way to act stupid twice. Because they've done it. If you're not aware of it, these are precedents you have to go look up. You say, I am citing Bigsby versus Hamster Humper over here. Compel them to answer intelligently, which means it goes from being a little form letter that can't be used in court to a legal decision by the ATF they have to stick with. That's how we ended up with bump stocks. They were asked by the companies, can we sell these? And then they outlawed them. Which is an about-face they were ordered to do during the Trump era because of Stephen Paddock. But when you and I ask them the question, it's an opinion letter on a technical subject with a narrow range. But they can rescind it later because they can change their opinion. However, if they do a dumbass like this on the second time, you could cite, basically, you cannot pretend to be ignorant, and now it's a legal restriction. You actually have to state whether there's a law here. And suddenly they're required to interpret law, and they can't change the answer for you and maybe for anybody else. This is the reason, nationally, I can buy a flare gun and stick a conversion cylinder that's rifled, that's below 50 caliber, don't make it 50 caliber, and fire it from any flare gun, as long as it doesn't blow up in my hands, or even if it does. And I can't be prosecuted. Number one, because it's legally been declared, because they had to admit it, it's an ordinary pistol. We're not going to classify it. They can never prosecute after that point. They have to shut up. They literally cut off their left nut. They don't have the power to rock'em sock'em you over the head for this stuff. Now, again, this is in that first form. It says when you do these inquiries, for that instance, they are not allowed to use this as evidence against you. So what did they determine? The ATF has been spending over a decade, several decades, allowing anybody to make a silencer. Or just go buy one. It's the same tax. You have to pay $200. But if you make one yourself, you have an interesting characteristic about it. You're requesting permission from them to make a firearm based on your zip code, address, everything. And you're stating, because you're doing this and you give them the $200 ahead of time, charge me the money if I'm required to have a tax stamp for doing this, refuse the money and or refund it, because it's not really regulated by you. And if it's not something you have to pay money for, they have to destroy the file. But you get to keep the copy. It's a lot like the opinion letter. It no longer has force of law, except it did. Now we get to the point that happened. A bunch of people figured out that you could make a silencer, let's say, by using a 50-gallon drum and shooting through it. It's not attached to the firearm. Even though it does everything a silencer does, it's in a fixed position. You're shooting at a target. It saves your ears. We'd like to use one at our shooting range. No response. okay, you played dumb, we're doing it again, and now we're asking for $200 tax stamp. Because they tricked them by doing a free request, getting it ignored, and then doing the $200 tax stamp, which means at the same time, they have to stick with the answer. If you make something non-man portable, it's not considered a silencer. We can't regulate it. Thank you for the $200 back. And the response also, you're not allowed to use my discussion of wanting to build these as an intent, and you are not allowed to raid my shooting range or my house. And then it got plastered all over the internet. You can make one of these oversized noise killers. It's literally just a noise killer. And they lost the ability to go after people using that as an excuse. So you turn in your form. The form doesn't require you to include construction parts or materials or tools. They send you a follow-up letter that isn't restricted from being used in court, asking for you to list construction parts and or tools and materials, and then claim any part, whether it's a washer or a screw, is a precursor component of what they regulate. Let's say a silencer or a machine gun. Or just make shit up. You need permission to possess these items. But in the process of doing so, they've been deliberately tricking people into saying, well, you don't have permission here. Give us a list and send us photos. This is because people bought kits with tools and parts and instructions. If they're all put together, they overtly state that's just a little too much. The whole idea with all of this is you're a person experimenting with building stuff. Let's say you're building literally a machine gun that's bolted to a table. They can optionally not charge you the $200 tax stamp because it's not truly a machine gun. If you build it a certain way that it can't ever actually be used to aim, much less shoot anybody, because it shoots straight into a bullet catcher, they're not going to demand the $200 tax stamp unless you're doing it for a business, in which case say, yeah, you have to pay the $200 tax stamp, you're all good. They can't come after you with intent because you have all the parts sitting there, because you have to build it from scratch. Almost everything that's an NFA permission slip request at $200 or whatever is based on you starting off building it from a lump of metal. But if you get a ready-made kit and it's sitting in your house, this shows intent to build it whether or not you get permission or not. Because there's a precedent for that. Yes, that's literally happened. Because people really did do that. And the ATF decided these are people showing intent to defy the NFA or GCA or whatever. So again, how do we get around that? Don't possess parts and make it obvious you haven't purchased them yet. Don't present yourself as trying to build even a normal firearm by starting with an 80% lower kit. Don't, because they consider that an instant kit, and they've decided it's just too much already prepped for you. I mean, really, in some cases it is. So they say, okay, you basically bought a lower receiver that doesn't have a serial number. That's against law. It has to be serialized first. And again, all of the companies just decided, well, we can just serialize the lower receiver and you finish it. And the ATF said, thank you. And then dropped the subject. Now, I don't know if anybody wants to bring that up. I mean, they are doing a catch-22 here. They're fucking with people because they're tired of giving $200 tax stamp approvals for everything other than machine guns. They won't do machine guns if you're not aware, unless, again, it's a weird one like I'm talking about. They got tired of these requests, and they got tired of being basically hounded by people. And they decided, everybody's a little too comfortable. Let's shake things up. Now, again, this isn't technically illegal for them to do it, but it obviously is an example of entrapment. And the way you get around it is, again, you photograph all the parts before you buy them. You give them links if it's stuff on Amazon and say, yeah, I'm building a suppressor. Well, I'd like to, but I need to know, start stupid. Is it legal for me to build a suppressor without paying the $200 tax stamp if I make it out of scratch? The letter is supposed to tell you no. You have to demonstrate ignorance and include everything they're going to ask for. So that, well, we need other photos of whatever you have. I don't have anything to send you. That means you can't be compelled to present self-incriminating evidence because you don't have any. And again, you can buy an 80% lower these days. It just has a serial number on it, and you have to have it go through the local pawn shop or some other federal firearms license location. Because people just complied with the rules and suddenly, well, they can't screw with anybody. This is an example of the ATF overtly trying to fuck with people, not just saying you got to serialize shit. And the way you get around it is don't have anything that they can come after you for, and actually, maliciously obey them to take away their power. Thanks for watching. Have a good day. Good luck.